Good morning to you. I'm Teresa Dufour. While CT Style remains on hiatus, we are bringing you today's CT Style Express. Now, during these uncertain times, many people have questions about personal injury and workers' compensation, and that's why News 8 has partnered with the Goff Law Group to bring you the law down. Attorney Brooke Goff is back here with us today, and we're focusing on slip and falls that happen at work. You deal with quite a few of these, don't you, Brooke?
I deal with them all the time. There's actually a study. We do a lot more research than most, but there's a study actually that tells you what kinds of cases are the most common comp cases brought, like how it happens. And I'm telling you, if I were on like what's this show, Who Wants to Be a Millionaire or something like this, I would have guessed slip and falls, right, would be number one. They actually weren't. It's car accidents, if you can believe it, car accident related work injuries. So, but slip and falls are a close, I think that was a close second. So dog bites are in there too. So yeah, but slip and falls, I see so many of them all the time, every day. That's why I would have guessed this. And I still want to see the statistics because I don't believe it's car accidents. But a lot of people think, okay, I slipped and fell. I'm going to bring a claim, right, against my workers' comp. However, they don't know that there's other remedies also available. So,
and what are those other remedies? Where do you start?
Well, if you fall, so all this is, it depends, right? Don't we hate that? So if you fall on property that's owned by your employer, that's managed by your employer, maintained by your employer, you may not have any other remedies, okay? Because you can't sue your employer in the state of Connecticut unless you meet certain exceptions. One of them is recklessness, but I always explain to people, I try to use a dramatic example of recklessness. So because everybody might be like, well, this was reckless and this was. Think of it like John Smith as a roofer, right? It's really icy up on a roof. The owner of the company says, John, go up there and check out that roof. He knows it's icy, right? The owner, he knows it's dangerous. John goes up there, checks out the roof, falls down, and let's say he injures his neck, right? Fine, that's one scenario. No recklessness there. Some people would argue it is, right? Because he knew it was icy, but it's not. Number two, John Smith is a roofer and his boss is like, look, I'm going to go up on the roof with you. He sees the ice there. He goes, I wonder if how slippery it is. Maybe I'll just try to push John Smith to see if he'd fall. He pushes John Smith falls, injures his neck. That's reckless, okay? That's literally the drama of that. You're sitting there saying, really, does this happen? Yes, it does. It's a real life example. But that dramatic element is what you need really typically for a reckless claim. Not always. I always encourage people to talk to people about it. But typically that is the dramatic element that you really need for a proper recklessness claim.
Got it. All right. So this is something you definitely want to work with an attorney on.
Well, you do, because, you know, the third party element's key. So let's say you are delivering packages to somebody's home, or let's say you're in the parking lot. There's so many delivery drivers and everything else. You're in the parking lot of a premises and you slip and fall on ice. Or let's say you're in your employer's parking lot, but maybe they have a snowplow contractor, right, that takes care of it. Or maybe the employer doesn't own the building and it's not their responsibility under the contract. Guys, you have a third party claim under that case, right? So you would bring your comp case against the employer, no problem. But then you might have a third party case against the snow contractor and or against the owner of the property, whatever the defect is, right? So when you hear like, I hate to say, but like bigger money cases, these are typically not comp cases. These are your third party cases. So you don't get pain and suffering in workers' comp. So if you can get that third party case, if you can get somebody in on that third party action and you can get your pain and suffering, that's a home run for you. And you want the same lawyer doing both cases. You want a PI attorney, we talked about this before, and a comp attorney that does both cases, the same attorney. You go somewhere else, it's to your detriment, because we can't leverage the comp lien because the attorneys start making decisions to benefit themselves instead of making decisions to benefit their clients. And so you want the same attorney doing both.
Got it. Do you have to file this immediately? Like
which one? Which part?
Either one. I mean,
comp claim or the third party?
Third
party of 2 years.
Okay.
Third party of 2 years. But don't wait 2 years. That's just 2 years. We always get those into pretty much. I mean, if it's a slip and fall, I usually file it within 6 months. But the comp claim, you should file it right away. There's a form called the 30C. But I always tell people, consult with a lawyer first, okay? Most people think that they filed a comp claim. They really haven't. They just told their employer and their employer's insurance gave them a claim number. That doesn't mean you have a comp claim, guys. Newsflash. Just because it's a claim number doesn't mean it's called a WCC number. And I can tell by just looking you up on the website to see if it's actually been filed. If you haven't filed a comp claim, the insurance company can mess with you all they want. You can't file it for a hearing because you don't have a comp claim without opening the claim properly, a 30C form. You can't do any of the above. So a lot of people think, oh, I've been doing it right all along. I'm telling you, 80% of people I talk to, no way. There's no claim open. They just think that everybody, you guys got to treat this like you think that the insurance companies are there to help you. But guys, they have a job. It's called mitigation of damages. They're not going to tell you how to handle your case so that they have to pay more money. It's just not going to happen. And by the way, they have lawyers in the back room that are telling them what to do. So it's you versus a bunch of lawyers and an insurance company. Good luck to you. That you should have a lawyer on every company.
And that's why you call Attorney Brookhoff. Thank you so much for
That's it. You know, you said it, Teresa, not me. So
very good.
Thanks, guys. Take it easy.
Your website, gofflawgroup.net. Find everything you need.
Yeah, and you can call us or text us, 203-399-0000. Yep.
Very good. Thanks, Attorney.
24/7, holidays, the whole bit. So
always working.
Thanks. Yeah, always working. Every day.